So, what we're going to be covering this course is we're going to talk why consultative planning is important, not only from an ethical standpoint, but from a standpoint of being a good consultant, the legal basis and best practices for consultative approach to benefits, what you need to do to lay a foundation. You can't do the same thing the same way you've been doing it and expect to become all automatically or just by virtue of a wave of a wand become consultative in approach. So there's a change in paradigm that has to occur. And then we're going to look at some of the consultative planning opportunities that come to the table, because one of the things I think we're all familiar with is the commission compression that's going on. But consultative is the true differentiator in benefits planning. When I talk in front of people, the most common answer I get to the question, what is it that differentiates you as a broker from your competition, service is the normal answer. And not that I don't want to say anything to minimize the value and the importance of good service to your clients, but I think it's more something that is expected by your clients than as a differentiator. So now we're going to start talking about best practices. That's what the state law says, okay, that you have the right to charge fees. I think best practices will dictate a lot more, and this is where the ethics comes in. Because again, if you're charging fees, you want to provide something, you've got to do something different and something more over and above what you're doing now. Okay, in most cases. Maybe not, but in most cases. You should not charge fees, I do not believe, for transacting insurance. And I will show you, we'll show a definition of transacting insurance. But wherever the commissions are, if you narrow it down to the definition of actually transacting insurance, the commissions are sufficient usually to pay you a reasonably good income for transacting insurance. It's all the ancillary stuff you have to do in order to make it work, unrelated to a specific product that makes it more difficult. Fees should only be charged, like I said, when non-transacting insurance. And as mentioned in your law, you should have a separate contract signed before you sell the insurance. Other best practices? Well, when are you transacting insurance? And I use California now because California does a very good job of making and setting up definitions of how they think it is, what it is. The insurance code is contained in Section 35 of their code, and I think it's a very good definition. It's a solicitation, negotiating preliminary to execution, execution of the contract itself, filling out the underwriting, doing the underwriting work, and any service work that goes along with it, transacting matters subsequent to the execution that arise out of it. In other words, basically, if it's a service work from a claim situation or a billing situation, that's transacting insurance. On the other hand, if it's something about a Section 125 plan that interacts with the insurance, that's not transacting insurance, because it's not specific to ABC Company's XYZ policy. If not for the existence of that policy, the service would not be required. Best practices continued. When are you transacting insurance? Like I said, the concept's pretty straightforward. Execution, execution of the contract of insurance and is relatively straightforward. Whoops, I went too far there. But matters arising out of it are distinguished from the matters simply relate to a policy. Arising out of it is only if that specific policy exists, i.e. a service issue, a billing issue, a specific question about the specific policy or contract. If it relates to it, it's anything else. Section 125, Section 105, COBRA, HIPAA, FNMLA, ERISA, PPACA advising. These are all things that are not transacting insurance that either you should be presenting to your client as value added, which it truly is, or possibly even considering charging a fee for. What other best practices do we need to continue? Well, you need to know about fee related to transacting insurance and what you need to do. Fees should be agreed to in advance by the client and the broker, and full disclosure of exactly what the services to be provided are for that. One of the things that I have charged fees for over the years and is very valid, you might want to start doing employee surveys to get feedback to find out what sort of products might fit a particular case the best. You can charge a fee for that. It's totally unrelated, and it certainly shows extra work and will help to differentiate you. The contract should be in writing. It can be verbal in California. I wouldn't try to get away with it, but all appropriate disclosures need to be made in the contract. Engagement agreements. California has 6 things they like to see put in an agreement. I think there's more, and we'll talk about that. You need to have the parties of the contract. That was in your law. The services to be performed. A plain statement that those services are outside the scope of any agency or relationship the producer might have with the insurance company, i.e. you're not selling insurance when you're doing it. The fee to be charged should be stated. That's what was in the Kansas law. Any other conditions to be enforced, such as limitations on the contract, refunding of any fees based upon workload, or actual charging more fees if certain things aren't done in a timely fashion, those things need to be disclosed in the contract. And then there's some sort of signature or expression of consent. Additionally, I think it's important, one point to consider when fees are charged is do not reduce waiver. We talked about that. You'll get into a rebating problem in Kansas, definitely. California has no anti-rebating laws, but I just would not do it. Don't diminish the value of what you're doing by adjusting your fee. If you're doing the work and the work justifies a fee, which I really think it does if you really put your shoulder to it, then don't vary it. It's not a negotiable thing. It is negotiable, but it's not something you would want to be playing around with a lot.